Welcome everybody to a very special webinar. The topic is the new USCIS AOS memo. It made major headlines last month, and now we're a month later, and we're going to talk about what we've actually seen on the ground. Some good news and some just general updates, and we're actually going to poll the audience to see what you've seen so that we can get some even better benchmarking. I just got back from ALA, the American Immigration Lawyers Association annual meeting yesterday, and I was just polling everybody. I was crowdsourcing, talking to everybody I could find, ex-government. So I have some good talking points, but we're going to get to that. Let's first talk about our panelists. Let's start with Karol. Karol Dywel is a global mobility and immigration partner at Robinhood. He has over a decade of experience spanning major corporate immigration law firms and tech-driven talent management. Karol brings a unique perspective to the table. He is an immigrant himself, so he understands the personal challenges and complexity of the process, and he is a fierce advocate for building seamless, empathetic, and scalable mobility programs. Welcome, Karol.
Hi, welcome everyone.
Yay, great. So Nicole Yunez is Senior HR and Global Mobility Leader. She is a Senior HR and Global Mobility Leader with 14 years of experience driving talent strategy, immigration programs, and organizational success. She's currently with Kroll, but she's also channeled her passion for people and innovation into entrepreneurship. And she is the founder of Nicole Clarice, which is a women-led sustainable fashion brand with elevated business casual dresses for active women using premium performance fabrics. I actually have a dress, this is the same one that she's wearing, and I absolutely love it. So plug, I almost wore it today. Anyway, Nicole serves on the board of the Corporate Relocation Council of Chicago, where she helps shape the future of global mobility. And she's also on the board of some really cool other organizations, Deborah's Place, and she also advocates for women overcoming homelessness. And I also think she does jujitsu, or is it karate? It's something incredible. I'm a woman of many talents. Welcome, Nicole. Judith Bergstresser. She is not on camera because we were having some technical difficulties, but can you give us a shout out, Judy?
Hi everyone. Glad to be on the panel.
Yay. Okay, welcome, Judy. Judith goes by Judy. She's a global mobility professional with over 20 years of experience in expat management with a focus on employment-based immigration matters, internal and domestic relocation, and expat taxation. She's worked in the pharmaceutical industry at Roan, and I'm going to mispronounce the name, Pauling, Rohr, Aventis, Wyeth, Pfizer, and most recently Evonik Corporation, which is a specialty chemical company. She lives in Pennsylvania in the Philadelphia suburbs with her husband and enjoys gardening and spending time with her grandkids. That is so cool. And I am Jihan Merlin. I'm the head of immigration strategy at Alma. We're a modern immigration law firm that combines legal guidance, expert legal guidance with technology to help companies hire and retain international talent. I'm an immigration attorney myself. I have over 13 years of experience advising employers on their U.S. business immigration programs. And currently at Alma, I partner with HR, people ops, mobility teams to help build their immigration programs and deal with complex situations. So with that, long introductions, we're going to jump into the agenda for today. And we're going to start with the memo itself, what it says, what the press release got wrong, and what the law has always said about discretion. We'll also get into what's actually happening in adjudications right now, including RFEs, adjustment of status interviews, just anything that's changed over the past month. And then from there, we'll talk through what employers should actually be doing in practical terms. Will the recording be sent over? I'm going to check on that with the panelists after the call, but we'll let you know. In any case, we'll send a summary that we can share with everybody, like some sort of helpful how-to. And the PowerPoint that I'm creating we'll share the slides. So that'll also be helpful. And then we'll turn it over to a Q&A and panelist discussion, and our panelists will share their advice on handling these types of announcements, internal conversations, communications, and lessons learned when they've had to navigate these things. And then we'll close with any of your questions. So you can keep them in the chat. We might get to them as we talk, or we might deal with them at the end. So just as you think of them, drop them in. We'll make sure that everybody gets an answer. Moving forward, for anyone newer to immigration, adjustment of status, also known as, call it AOS, we call it I-485. It's a process that allows foreign nationals who are already inside the US to apply for a green card without leaving the country. So they file Form I-485 I-45 with USCIS. The alternative to adjustment is consular processing, where the person travels abroad and goes through the immigrant visa process at a U.S. embassy or consulate. For your employees, especially those on H-1B or L or other work visas that have an approved pending green card petition, AOS has been the default path. Adjustment of status, it keeps them in the U.S., it keeps them working, helps to avoid disruptions, and generally has been considered the lower risk approach. So that's the backdrop of adjustments. So with that, on May 21st, USCIS issued a new policy memo, 6020199. It called adjustment of status a matter of discretion and administrative grace and extraordinary relief. So we're going to spend a few minutes unpacking what it actually says, because the memo and the announcement actually followed very different stories. So the thing that everybody latched onto is May 22nd, USCIS put out a press release, here we go, announcing publicly that adjustment of statuses would only be approved in extraordinary circumstances and that applicants should generally return home to apply. So the USCIS spokesperson, Zach Kaler, I'm mispronouncing his name, I'm sure, told reporters that foreign nationals in the US are generally expected to return home to their countries. So that quote went everywhere, and that phrase, only in extraordinary circumstances, however, does not appear in the memo itself. So there was, from the very beginning, there was these two separate realities, where there was a memo, which much more with tempered language, and this crazy announcement. So it was just very different from the beginning. And also the headlines did not help. So you had major news outlets like even the New York Times saying green card seekers must leave the US. And a lot of mobility teams, and Karol and Nicole, maybe you can speak to this, and were just flooded with questions from foreign nationals who read these headlines and were like, what am I going to have to do? What does this mean for me? And at that point, we really didn't know. But let's dig into what the Immigration and Nationality Act actually says. The actual statute provides for adjustment of status when an applicant submits an application, is eligible and admissible, and a visa number is available. So basically their priority date is current. The statute does give the Attorney General discretion, but it does not say that consular processing is the default, and it does not say that applicants have to leave. There's also this precedent decision called Matter of Array, and the memo doesn't cite this at all, but that holds that when there are no adverse factors, an adjustment application should normally be approved. This particular memo adopted an unusual or outstanding equities language, but that was from Matter of Array, but left that holding out entirely. So it's basically just cherry pick what it wanted to from the law. We'll talk more about that in a minute. But legally, what's changed, what hasn't changed? Right away, we knew there was a disparity. We knew that what was announced wasn't following the letter of the law, and that if it was enforced, what are we going to do about it? Would there be litigation? What does it mean? So bottom line, Congress has not amended the Immigration and Nationality Act. The regulations have not changed. That would require a notice and rulemaking process. The form I-45 form instructions, which do carry force of law in terms of regulations, they have not changed. And I even checked yesterday, they still have not changed. The adjustment of status is still a legal option. So the discretion, however, has always been a part of that process. And that's something that we haven't honestly paid a lot of attention to, because it's sort of just been sitting there in the background. We always knew if somebody had something in their background, like a criminal history or a DUI, that was something to pay attention to, but it all comes down to discretion. That's where that factors in. So even if someone isn't technically inadmissible, the law has always been there allowing for discretion. What's changed is that this memo kind of puts a spotlight on discretion and the framing around it, but the law itself has not changed, bottom line. But I want to talk a little bit about what we saw in the immediate aftermath of this memo. The memo, and I want to just point out one other thing, the memo explicitly preserved adjustment of status for dual intent holders. So it actually called out that H-1B and L-1 are not inconsistent statuses when it came to adjustment of status, but it was silent when it came to non-dual intent statuses, even O's, but also TNs and E3s. And that immediately raised questions for employers, like, what does this mean for all of my non-dual intent visa holders? Are the ones that are pending, the newer ones, should we proceed with filing? What's the appropriate path? And while this is happening in the immediate aftermath, we started hearing about new questions appearing at some adjustment of status interviews. Questions like, why did you apply for adjustment of status instead of consular processing? Are there factors preventing you from going abroad? What are your family ties? Not at any interview, but still enough for it to, it's definitely widely circulated. And then there were a handful of these RFEs that you guys might have seen on LinkedIn being widely circulated, or Reddit or wherever, and they were requesting proof of discretionary factors like family ties and other things. And it's actually unclear whether these RFEs came before or after the memo. There wasn't a lot of information, but we'll actually break that down in a minute because they do seem to be few and far between, but that's its own thing we'll talk about. So fortunately, within a week of the memo coming out, there was what seemed to be a walk back. So on May 29th, there was DHS spokesperson who wouldn't be named, who said, oh, this is actually just a reminder to officers of their discretionary authority, which has always been there on a case-by-case basis, and this really shouldn't impact most employment-based cases where they're eligible. So, but still people were pretty shaken and they didn't really know what that would mean. So that's when we decided to schedule this webinar. We're like, we just don't know what's going on, but I think it would be helpful to schedule something a month later and see where the dust is. And we'll have some time to get some data points and hear from people and crowdsource some information and hopefully see something. So still early days, but we're going to share a little bit about what we saw. So based on the most recent AILA update, and this is also what I heard during the conference yesterday, there have been reports that officers are no longer asking those additional questions at the AOS interviews, and that they were always sort of a few field offices may have been doing it and not others, and it was really like just a range of different reports, but we're hearing that those questions have really died down. And I was talking to two different ex-USCIS officials who still have contacts on the inside, and so this is obviously hearsay, but what I heard was that when this announcement came out, there was very little guidance given to the officers, if at all. And so similar to when the $100,000 H-1B proclamation was made, the officers were scrambling, the field offices were scrambling and trying to understand how they should implement it. And so these questions, or the hypothesis, and these people I spoke to, was that these questions were an attempt to proactively get information from people in the absence of guidance from the agency so that they could have it on in file and not have to issue an RFE down the road once they got additional guidance. And so that is the sort of what I heard of why they're asking these questions. It wasn't a directive from the agency as far as I heard, but rather an attempt to get information proactively, which I thought was interesting. And I already talked about this sort of walk back of the memo. So if it doesn't prevent people from who qualify from seeking adjustment of status, the law hasn't changed, et cetera, et cetera. So a month in, I'm happy to report that if you have an applicant who is eligible under the letter of the law to adjust status, as in the past, especially in the employment-based context, they should continue. That standard should continue to apply to them. However, we have this discretionary thing that's always been there, and that agents in this new administration in general have been expected to pay more attention. So already before this memo came out, I was hearing from practitioners that there has been a slight uptick in discretionary denial. So think of a situation where maybe a person had a prior, like a petty offense that maybe could have been forgiven under the statute as like under the petty offense exception, but now it's sort of reflecting on their moral character. And so now it's being weighed in a way that maybe it hadn't been before. So again, these are early days, but we're seeing the discretion's always been there, but maybe we're paying more attention to it. And this is an opportunity for attorneys to do some real lawyering. And so that was another thing that I heard. And I'm going to move this slide. We're going to talk about discretion, favorable discretion, because that's always been there. And there are positive factors and negative factors. So the standard of favorable discretion in the adjustment of status context is actually written into a USCIS policy manual in Chapter 10, Volume 7, Part A, something, something. So feel free to take a look at that or have your attorneys do that. But here's a sort of a summary, what that looks like in practice. Assuming somebody meets the AOS eligibility requirements, there are also factors like family ties in the U.S. What the hardship would be if somebody's denied, if they've lived in the U.S. for a long time, especially from a young age, invalid status without any immigration violations, a history of compliance with immigration laws, owning property in the U.S., having strong business ties, good moral character. This is this mushy concept of are you a good, sort of like, do you there's so many things, like, do you volunteer? Do you pay your taxes? That's a really big one. And I was listening to a panel specifically on the discretionary adjudications in the AOS context. And one of the recommendations I heard was to include proactively a statement in adjustment of status cover letters, particularly where there are negative factors, but in any case, describing that a favorable exercise of discretion is warranted. So this list of positive and negative factors, it's non-exhaustive. I just talked about good moral character. So one thing that they were mentioning is taking care of a sick parent. If you're a single parent, taking care of children, community involvement, educational attainment, if you've gone to college, if you persevered. I talked about the taxes. Negative factors would be like DUI convictions, reckless driving, those kinds of things. There's also an argument to be made about rehabilitation. So if somebody has one of those negative factors, then it's going to be really important to include an argument about how they have sort of turned things around, how they've improved. So that's sort of the proactive recommendation, whereas before, kind of just sort of, obviously answer all the questions correctly on the adjustment form, but not like call attention to things. It does seem that I talked to a few ex-USCIS officers that agreed they would rather have the information up front and it just sort of like move past it than have to issue an RFE. So that the overall advice is consider including a discretionary statement in your adjustment of status filings. Not to say that if you don't, it's going to cause an RFE, but that's just one of those practical tips if you want to have a leg up in the process. Major takeaways. Number one takeaway is don't panic. The law has not changed. Adjustment of status still remains a viable green card pathway. However, it would be beneficial to consider instructing your employees to maintain clear documentation of their lawful status, complete work history and address history, maintain copies of their prior DS-160 applications. That's something that the law firms don't always have access to if they did it on their own. So clear documentation that they've complied with immigration laws. Also, be sure to partner with counsel to identify any negative factors early. Like I said, consider proactively including a favorable discussion statement, and for higher scrutiny cases, do be sure to describe any mitigating circumstances and include documentation supporting favorable discretion. And then communicating with employees, we'll talk as a group about this, but my first inclination is to say, the law has not changed and adjustment of status remains a viable pathway. So, but either way, do expect USCIS discretion may play a higher role in these adjudications going forward. I appreciate everybody. Thank you for giving us an hour of your time. Hopefully this was helpful. I'd love to get any feedback if you thought it was or wasn't. And we're hoping to have another panel possibly next month on summer travel and travel disruptions and things to keep in mind. But look out for that potentially. And there's also going to be an immigration panel on other sort of breaking issues. So we'll circulate that when we have it. But in the meantime, everybody have a great day, and we'll see each other later.